going to look at 5 different areas. I'll give you an overview of electronic disclosure. I'm going to talk a little bit about the rules. And then I want to focus on 3 particular areas. There's lots of different areas within electronic disclosure. We're going to focus on 3 particular areas. These are the different sections of electronic disclosure. You can see them in that model. You can look at it on the internet if you want to. If we just look through all of these, I mean, you'd be familiar with, if you've done any electronic disclosure, for many people, it's really about the review. That's what people think of when they think of electronic disclosure. Someone is going to have to sit down and is going to have to review some electronic documents to work out whether or not those documents are disclosable. But there's lots of other stages. Right from the outset, and as I say, I'm going to talk about some of these stages in detail. I'm going to focus on these early stages because that's when you need to get it right. Because this is a ship that is quite hard to turn around if you don't get it right. It is possible, but it is a ship that it can be hard to turn around if you don't get it right. So when we go through this, I am going to focus on identification, preservation, and then I will also look at review. When you're looking at those different boxes and you think, well, I've got to get through all of those different boxes, there's actually still more to do with electronic disclosure because that's just your disclosure. That's just the bit that you've got to read and you've got to review. But there's a lot more to electronic disclosure. You've got the other side's disclosure that's going to come to you. You need to be ready for that and work out what you're going to do. When that does arrive, your focus on that will be on reviewing it and analysing it and feeding it into the case. You might have specific disclosure. Electronic disclosure done properly, it's probably inevitably going to lead to some specific disclosure because the whole thing is if you're winning at electronic disclosure, you're going to start attacking the other side's disclosure. And that's when you might look to use the weaponry of a specific disclosure application. You've got ongoing obligations. You've got clients saying, did I ever show you this document? It's like, no, you never showed me that document. It's like a nightmare. And that's an ongoing obligation of what you're going to do with that document. You've got a judge looking at what's happening as this process goes on, and you get judges being much more interventionist now. And then you've got me moving that disclosure that you've done into your witness statements. And that's the quotation, you tell them I'm coming and hell's coming with me. But I've crossed it out. I've crossed it out because wonderful though that movie is, it's sort of not the attitude to take in electronic disclosure. The court look for something altogether different. You're meant to actually look to cooperate at as early a stage as possible. This case is still a very, very relevant case from the early days of electronic disclosure. Mr. Justice Morgan was sitting in this case. And I've got 3 bullet points there. One, the most important one, is the second one, which is that right from the outset, a judge recognized that electronic disclosure is an imperfect mechanism. And if you do it, even if you do it perfectly, there's absolutely no guarantee you will get all of the documents that you were meant to get before the other side, that they'll get all the documents that they were thinking they would get before you, that the judge will get all of the documents the judge thinks are relevant before the judge. It's an imperfect system. So that's fine. Right? It's not a bad thing if you've missed out on this, as long as you've put in place a process and a procedure that you can say, listen, I know that hasn't been disclosed, but what we actually did was right. The process that we adopted was fair and reasonable and proportionate. So that second bullet point is that even if a smoking gun isn't found, that's not the end of the world. What could be the end of the world is if you haven't done it in the right way and haven't built yourself up a methodology that you can support. The third bullet point on there about emails and the idea that people are more relaxed in emails, I actually think that's probably changed over the last kind of 20 years or so. When that was written, there was like letters and then there was emails. Now, emails are so much more like how business correspondence is done. That I think you'd replace emails with text messages now is where people's guard is down the most. Actually, people craft emails these days, spend a lot of time on them, so it's not necessarily the same thing. When you're doing electronic disclosure, you're going to have 2 different potential routes. For most of the work that you do, if it's electronic disclosure, you'll be going through business and property court type work. And that will mean you'll be following the civil procedure rules and the practice direction 57 AD. But there is another route. It still exists. It existed before that practice direction came along, and that is CPR 31, practice direction 31B. So if you're not doing a business and property case, you need to look and think, well, is CPR 31, does it apply? What have I done here is pointed out to you that there's a big difference. I mean, it's really quite a significant difference if you're faced with something going down the route of CPR 31 compared to the Business and Property Code route. Some things are the same, like the definition of a document. Third-party disclosure is not changed, but some things are really quite significantly different. And so, therefore, it is well worth taking stock and making sure you've got a really good understanding, because even if you've done it before down that route, it's just not the same. What I think is very important to understand about disclosure is, although I said it's hard to turn the ship around, it is hard to turn the ship around because expenses get incurred, you start moving along. Disclosure is one of the very few areas where the court is prepared to listen to you and hear what you've got to say without thinking about the cost consequences. If you're going to say to parties, cooperate, which is what's said about electronic disclosure, what a great idea it is to then support that with a judicial framework that says, listen, if you can't cooperate, come and talk back to me, and I'll then help you to cooperate. And as opposed to the normal situation, like, oh, if we make this application and look at costs and we'll lose, and it'll be an absolute nightmare. With disclosure guidance hearings, the position is there's no party will be bearing the cost unless, like, really someone's behaving in a particularly obtuse and difficult way. But generally, that's just not the position. And I think that's well worth bearing in mind. If you're stuck and you're concerned about what's happening with your disclosure, getting in front of the court, yeah, it always costs money to get in front of the court, but the idea that you've got no cost consequences is well worth bearing in mind. This particular case, however, is an example where there was cost consequences. And it's a case that's worth reading because it was essentially just not managed in the right way by the party. They turned up at court. They kind of took it all as if, like, oh, yeah, you can turn it anytime you want. It'll be absolutely fine. The first time they really laid out the issues was in the skeleton arguments. The whole thing was just not done in the right kind of way. And in the end, although it is ordinary cost in the case, the cost in the end went against one of the parties here. So it is worth bearing in mind. It's not always cost-free, but generally, if you behave reasonably, it is a staggeringly unlikely scenario that the court will do anything other than say, well, here's my thoughts. Go away and keep cooperating. And we're now going to focus on identification. And the reason why I'm saying this is a good quotation for identification is this is the first part of the electronic disclosure model, right at the top. And this is the one that you just have to upfront invest in order to make sure that later on, as you flow through that model, you are controlling things in a cost-efficient manner. So, identification, what might be relevant, where could it be, how can we get to it, and then finally, how much might there be? Those are the kind of questions you'll think about with identification. To me, if you're going to do electronic disclosure and identification, you should, right from the outset, be putting together the list of issues. Now, if you've ever had to deal with a list of issues in electronic disclosure, it can be difficult. We'll talk about it shortly, but you should really be doing one of yourself as soon as you're faced with any kind of electronic disclosure situation, because it's that list of issues, you get that right, that then gives you that degree of control. You're going to have to talk to some people in IT. You might need someone else who's IT literate if you don't feel comfortable with that. But it's really, really important to understand not just the business, but also IT. And it can make a very big difference. So I did electronic disclosure once where it was like the chief executive or managing director of the company, and then there was like 5 other custodians being the people whose documents you generally get. And we disclosed the managing director's emails. It was a big case, like say 20,000 documents disclosed on each side, of which our managing director's document that he disclosed was a grand total of 1 email. The other side were understandably a little bit puzzled about this, and immediately, because they were really nice firm of solicitors, raised it in aggressive correspondence as to how we must be in breach of various rules. But actually what happened was that the managing director had an administrative assistant. And what she would do, because this is how he liked it, was every email that he got, she would print out for him, and then she'd delete the email so that, in fact, he didn't have any emails at all. What he had was all paper disclosure, right? But if we hadn't sat down and kind of taken the time to sit with the administrative assistant with him, we wouldn't have understood that situation. We could have been caught as well because these things happen so quickly. It's quickly momentum, the snowball. It's worth taking the time to understand the business and the IT department. E-disclosure providers, you must probably have been contacted by. There's so many out there desperate for your business. They can be, my own experience is that when dealt with properly, they can be really, really useful, particularly at the early stages where you might be able to get some insight into your own documents before you even have to disclose them, to give you some insight into the case, for example. And then finally, at that early stage, if you're going to get into your own documents, just bear in mind, you might have to disclose adverse documents however it goes down. So the more you're digging around, it maybe could end up with a situation where you're like, God, I really wish I hadn't opened that one. But it's just something to bear in mind. Custodians, sources, and date ranges. These are the kind of the cores, things about which you're going to have to think about when you're trying to put together the exercise right from the outset. I won't spend any particular time on that. And then this is the business and property court process. So we're into really how you can, essentially, the process that was adopted in Part 31 was meant to cut down on the amount of documents. And despite all of the effort to try and do that, the number of documents just kept on getting bigger. And so now the business and property courts have come up with another model designed to, again, try and cut down on the number of documents. So it offers more inventive ways of doing electronic disclosure. That's really where most times you sit, in search-based standard disclosure. Doing keywords, date ranges, searching, bringing back documents, reviewing the documents. That's where you generally sit. It's very rare to have wider than that, very rare, where you've got kind of line of inquiry type stuff. Request-led search-based sounds like it's better, but in my own experience, it's actually quite hard to construct searches that aren't in the end just another form of kind of keywords and documents. When you are looking at your initial disclosure and thinking about that sort of first stage, you need to already be thinking about, well, where am I going to go in terms of the levels of disclosure that I'm going to do? What of these different models might I want to be doing? And if you want one of these three models where you think this is what we need to do, that is going to trigger the whole process, right? And that's going to end up probably in a cost and case management conference. The whole process will be inevitably more expensive, and it will require, horror of horrors, the disclosure review document, which is, great in many ways. Like if you don't know anything about electronic disclosure and you are faced with that document will help you a lot. It will take you through it step by step. It's intimidating and it kind of takes time to do, but it is quite archly constructed. And if you know nothing and you just follow that document, you will at least put together some sort of methodology that on the face of it is kind of sustainable. So investing the time in doing it right is a really, really good idea. All those different things you need to think about when doing the disclosure review document. There is a simpler version. This case is a cracking case because this case was where, and this can happen to anyone doing electronic disclosure, it's where you go to the client and say like, oh, does anyone do any like personal stuff on, do business stuff on the personal like chat messages, that kind of, no, we do not. And you're like, oh, thank goodness for that. That's so much better for us because otherwise we have to collect errors, So it's like, brilliant. That's absolutely brilliant. Except the thing is, it happens all the time. So if you take at face value a client say, no, we don't, you could end up in a position like this. And in particular, a position like this where the 2-year-old son of one of the custodians was playing on YouTube and then on her version of events accidentally deleted the WeChat messages whilst playing on YouTube on her phone. It says if the destruction of the WeChat messages was deliberate, really, like, one does wonder. But the case itself is an interesting case, and but the point being is that taking at face value what you're told, because it just is immediately a relief to you that it's like, well, that does save on us having to deal with like data privacy issues, having to collect people's personal devices, is a risky business. The list of issues. So, I've just been involved in doing a list of issues, and I went into it thinking like, I'm only going to do like 6 issues because I am an expert in this whole thing, and I know you just meant to do a few issues. No, it like ended up with like 22. And it's like, what? I was just like, oh, really? Is that the best you can do? And it felt like it was the best I could do because it just, even though I tried to kind of get it down, you just end up with too many issues. So the kind of wording here, that it's not a mechanical exercise using the pleadings to create the list of issues that are between the cases. It's true, but it is hard. And you know, it fits quite nicely because there is a mosquito preserved in amber because we're going to focus on preservation. I mean, if you were to speak to an American company about preservation, it is absolutely the thing they are the most scared about when in litigation. The thought that you might fail to preserve documents. It's probably a little bit less so here, but I think it's getting more significant. Getting the preservation right, making sure the clients don't delete documents, suspending automated deletion if the client's already got that set up. All of those are key things in relation to preservation. PD 57AD is really strong on preservation compared to CPR 31. It's noticeably different. And so here, like just, I say, if you've got a client that's kind of a medium-sized company, maybe got in place IT policies that are going to actually kind of delete documents, chat messages. You need to think very carefully about that. Putting together a plan. So when I worked in UBS, we used to have to produce a preservation plan for every case, an actual plan saying, this is what we're going to do. These are the custodians, these are the different date sources, this is how we're going to do it. Every single case had what's called a preservation plan. It just means that later on, you can say, if something's gone missing, you say, well, we put in place a plan. I bet the other side didn't. We put in place a plan, and it was a good plan, even if something then went wrong. What I just want to say about review is that this is a sort of typical review. Push all the documents into a system, review all the documents. And that's a very typical review. You have to read your date range, custodians, etc. But you can be more complex, and it can be more efficient. Thinking about, like, you can do analysis to say, well, if I do all of this, how much data will I end up? You can actually get an insight early doors and then think, well, I can make a case that I shouldn't do it all because there'll be too much data. You can do an early case assessment. When you've got the documents there, what about looking at them to work out whether your case is any good? Like, don't just start reviewing thousands of documents. Maybe spend a couple of days, get someone in and say, well, listen, you're good on the system, fire up the good stuff and come back to me and tell me, have we got a good case? Don't waste the opportunity when you've got your documents there.